my lord.
This was extended.
This was subsequently extended, my lord. But
Because, where is the extension?
my lord,
Then without that, how can you argue the
my
matter?
lord, so far the section 23 is concerned. My lord, it only talks that the person is required to have the qualification.
When were you appointed?
My lord, I was appointed in 2019 pursuant to the order of the court, my lord, honorable court.
Then you are required to fulfill the criteria.
IA number 2 of 2023, my lord, is for condonation of delay of, my lord, 31 days.
Where have you stated in which paragraph 31 days delay?
My lord, in para 1 itself, my lord.
Para 1.
Para 1 of IA number 2 of 2023.
It heard IA 2 of 2023 for condonation of delay in filing LP for the reasons stated in the application and affidavit. You have 31 days in filing LPA. Stands condoned. IA Lord. Merit.
My lords, on merit, my lord, the appellants, there are two appellants before your lordships. My lord, they were appointed as on the post of Panchayat teacher.
Panchayat teacher.
Panchayat teacher. My lords, pursuant to the direction of the state appellate authority, my lord, Patna.
No, they were selected and appointed.
They were selected and appointed, my lord, in the year 2019. And my lord, subsequently, the state government, in view of, my lord, if my lord will be kind enough to see, in the writ application, my lord, annexure 1, they have issued the annexure 1 stating that all the teachers who have not completed their training within till 31st of March 2019, they will be removed from the service. This was the, my lord's, notification of the state government, my lord. My lords, now, my lords, this has been issued on 13/11/2000, my lords, 20. My lord, this has been issued under, my lord, the provision of section 23 of right to compulsory education to children. This has been issued.
So, in terms of annexure 1, you are required to pass
the training examination.
30.
But my lords,
2019.
my lord will find at the top, my lord, is there. आप अवगत है कि प्रासंगिक अधिनियम की धारा 23, my lord.
This was extended.
This was subsequently extended, my lord. But
Because, where is the extension?
my lord, so far that aspect is concerned, my lord, section 23, my lord.
Sir, where is the extension, sir?
My lord, it was so far in the year 2007 it was extended. After 2019.
2007 extended for how many years?
2017.
17 extended for how many years?
My lord, so only for, my lord, that letter I do not have. For
Then without that, how can you argue the
my
matter?
lord, so far the section 23 is concerned. My lord, it only talks that the person is required to have the qualification of the training. My lords, it doesn't talk that the person who will be appointed pursuant to the order of the court or subsequently they will be removed from service if they do not acquire the training. My lords, my case is that, my lord, I was appointed on the post.
What is the date on which it was prescribed?
My lord, the rules.
No, that training is a mandatory.
My lord, the training is mandatory is in section 23.
Prescribed under section?
Section 23.
23 of what?
Right of Children to Free and Compulsory Education Act 2009.
What is the date of this introduction of this act?
My lord, in the year 2009 itself.
2009. Then when were you appointed?
My lord, I was appointed in 2019 pursuant to the order of the court, my lord, honorable court.
Then you are required to fulfill the criteria.
My lord, that was, my lord, for that purpose I was showing that act. I was.
That is the reason an opportunity has been given to given to such of those appointees to acquire this qualification, and time has been extended.
My lord, when I filed an appeal before the authority, my lord, pursuant to this honorable court direction, I moved before the state appellate authority. My lord, the state did not raise the objection that such persons cannot be appointed now. My lord, in the act also, it is nowhere mentioned that the person who will not come pass the training examination, they will be terminated from service.
No, that need not be. It is an essential qualification.
It is, my lord, so far that is.
At the time of appointment, they did not. They ignored this criteria. At the time of appointment, state government or whatever the selecting authority, they have ignored this section 23.
My lord, it is.
Therefore, thereafter you have been given an opportunity. I think 2 years. You did not gain that.
2 years. We have taken. My lord, sir, it is for the state to send me for the training. I have taken, my lord, admission for the training sessions.
Where is that?
My lord, that is with the writ petition itself.
Huh?
In the writ petition.
What date you have undertaken?
My lords, I am just giving you. My lords, so far appellant number 1 is concerned, my lord, he has taken on 22nd of December 2019.
But that is beyond the period.
My lord, my lords, I was appointed in 2019, my lord.
Maybe.
My lords, it is not the fault of the appellant that he is not, my lord, willing, he cannot say.
Your appointment is illegal or not?
My lords, that
Your appointment is illegal
lords,
or not?
that aspect is concerned, the state out to have, my lords, taken a stand before the authority that they cannot.
All right, that's all.
My lord, that has not been done.
All right, that's
And
all.
now, my lords, after my lord, several persons like the appellants are being removed, my
No,
lord.
sir. You don't have case.
My lords, may kindly see section 23 of the act, my lord. And in the principal.
Sir, we have already seen in the previous bench.
My lords, perhaps, my lord, this has not been decided.
All right, we will decide now itself.
My lords, in the act itself, my lords.
Decide whether section 26 is operating on what, at what point of time. In fact, it is a state mistake.
That's what my lords I am telling.
Correct.
So, my lords.
So illegality committed by state is.
At least a one-time measure.
Sir, illegality committed by the state is to be blessed by this court.
My lords, so far that aspect is concerned. My lord, state could have, my lord, several teachers would be affected by this. My lords.
Quite natural. Quite natural.
As a one-time measure, the state could have, my lords, taken the persons who were appointed, my lord.
Withdraw and approach the court, state. If they want to give, they will give.
Well, they
have a policy decision.
They have already issued the letter by which they will be terminating the services.
In the instant, LK, appellant has assailed the order dated 19/10/2022, passed in CWJC so and so. The appellant was appointed, appellants were appointed as a Panchayat teacher in the year 2017. The selecting and appointing authority have failed to take note of eligibility criteria under section 23 of Right to Children Education Over Act. Section 23 reads as under. The selecting and appointing authority have failed to take note of the aforesaid criteria before selecting and appointing and similarly situated person. This was a subject matter of litigation. Taking note of the error committed by the authorities have extended 2 years time to acquire the requisite qualifications stated in the section 23 of so and so act. Since appellants failed to acquire the aforementioned qualification for the purpose of appointment to the post of Panchayat teacher, read with the fact that they were given sufficient time so the appellants failed to acquire the requisite qualification. The same was taken note of by the land single judge while dismissing the writ appellants. Next by land counsel for the appellant vehemently contended that selecting and appointing authority should have insisted at the time of appointment that they were required to fulfill the eligibility criteria mentioned under section 23 of so and so act. Therefore, they are entitled to some more time to acquire the aforementioned qualification. Courts cannot extend time limit for acquisition of any qualification in order to regularize selection and appointment to a particular post. So it is a policy decision of the state. Therefore, no infirmity is forthcoming from the order of the learned single judge. Accordingly, LPS stand dismissed.
Pleasure.